Hi, my name is Amanda Ridding. I consider myself, and I start this every time, but I do it in case someone's new to my channel. I consider myself to be a self-educating amateur student of law. And what I am trying to do with this channel is to help other Canadians better understand how the law operates in Canada by giving them a bit of a foundation on the law. I've been uploading recently videos on jurisdiction so people can understand how jurisdiction is established, and what is jurisdiction, and is it just one jurisdiction or multiple jurisdictions that are being established every time you walk into a court. So someone said they don't quite understand it, so I want to just tell a little story really quickly to hopefully put it into some perspective. So very recently, a lot of people have been walking into court under the Provincial Offences Act with Reopening of Ontario Act tickets, and they walk into court with a motion to dismiss or a motion to withdraw, no chance of a conviction or something along that lines. And so someone contacted me this week and said to me, could you look my motion over? So I was looking at the motion, and the motion said motion to dismiss, no chance of a conviction. And I said, well, it's fine that you've got this in here, but what rule under the Provincial Offences Act are you using to ask the court to dismiss it? And he said, well, I don't know. So I said, let's take a look. So we went into the Provincial Offences Act, and we could not find a motion to dismiss. We couldn't find a motion to withdraw. And I realized as soon as we saw that there is no rule to dismiss. There is no rule to do a withdrawal. And since there is no rule, if you walk into court and you present a motion to withdraw or to dismiss, that motion's not going to go anywhere, folks, because there's no rule that allows the court, if the court decides that your grounds for requesting the motion are justified, there's no that rule doesn't exist. So the court can't dismiss. The court doesn't have the authority to dismiss. The court doesn't have the authority to withdraw on a motion. Now, maybe on an application, but not on a motion. And they're two different things. Those are two different instruments in law. So when you understand that, then you understand that the motion to dismiss, that motion to withdraw, is going to fail. And so I said, well, so we went through the Provincial Offences Act, and what we determined was what he needed to do was a motion to quash under Rule 36, subsection 1. A motion to quash, he could ask the court, if he could prove that the ticket was not clear and regular on its face, he could ask the court to quash the information. And by quashing the information, it's gone, it's done, it's goodbye. So that's what we ended up doing. I advised him that he wants to use the rule, because without the rule, the court has no authority to do it. Now, let's take this on the flip side. I know someone, before I myself had actually stopped to think about this, I have in the past done motions to dismiss. In the past, I've done motions to withdraw for the same things. And in those instances, they always failed, and I'll use my Fire Prevention and Protection Act as an example. The Fire Prevention and Protection Act, I did a motion to dismiss, multiple motions to dismiss for multiple reasons. And in that I discovered, now that I've learned, my education has progressed so much since 2016, that I never established jurisdiction, which is why the trial had to happen, which is why I then had to go to an appeal, which is a miscarriage of justice because it dragged it on much longer than it actually had to. And in the appeal, we finally won. But we had to have the conviction first to get the appeal, because the motions that I presented never had jurisdiction. So because the motions never had jurisdiction, the motions alone could not be appealed under the rules. So now that you understand that, now let me explain something else to you. In hindsight, I went in and I presented a motion to dismiss and a motion to withdraw back in 2016. And that prosecutor played along, and that prosecutor argued why I didn't have, why the court shouldn't give me a motion to dismiss, why the court shouldn't give me a withdrawal. And it was all a bunch of bupkis. Okay, I had evidence to prove why the motions should be allowed, and the prosecutor just gave a lot of lip service and conjecture. And in hindsight, that prosecutor, under the Law Society of Ontario, is supposed to be competent enough in the law to know that I didn't have jurisdiction. By arguing against me before the court, that prosecutor showed incompetence, causing a misrepresentation of the law and misleading me, making me think I was getting an opportunity to be heard, and in reality, I wasn't being heard at all, because I never had jurisdiction of the court. The court could never have given me that motion to dismiss, because the rule didn't exist for the court to give it. Now, think about it, folks. For every person out there in Canada who has gone into a provincial offences court and filed a motion to dismiss or a motion to withdraw, go back to your Provincial Offences Act. If you're in Ontario, I can tell you right now, you've never had jurisdiction. And if you're in another province, go look at your provincial act, and you see if there's a motion to dismiss. Which means, folks, that if at least in Ontario, if a motion to dismiss if they're playing out this show, this dog and pony show, and allowing you to present your motion and then giving a ruling on a motion that doesn't have jurisdiction, the court has misled you and failed to show competence, causing distrust in the court system, and so is the prosecution. What do you think of that? Think about it. Think about it. When the rule doesn't exist, the very first thing out of their mouths should always be, you don't have jurisdiction, it's not properly before the court. And more importantly, there's a rule under the Courts of Justice Act, and I can't remember the rule number, the Judges Act. Under the Judges Act, they actually have to tell you what the rule is. It's the law, folks. And I have case law that supports that law. And if they don't tell you, first, that you don't have jurisdiction, and second, why you don't have jurisdiction, and third, what rules should be used in your application, they're breaking the law. And they're misguiding you, and they're misrepresenting the justice system. And it's a dog and pony show. And they don't use the words jurisdiction with Canadians, because this is how they get away with it. This is how they get away with it. And I hope that helps to put a little more perspective on why I'm trying to put it out there, the foundations of law that will hopefully help people get a better grounding on how it works. So when they do something they don't have the right to do because it's not written in law, you can call them out. Good luck. Thanks.